Hybrid mock arbitrations. We're online and we're here in physical presence. People online can't see the number of people here, and of course we can't see everybody online. I'm told we're going to have 200 to 300 people attending these mock arbitrations, which is pretty cool. Well done, Brad, for all the organisation. This is really quite a major event now, and I think in future years we'll have to continue with the hybrid. This is obviously a great success. It's very good. So, welcome to the mock arbitrations this afternoon. And I'll get straight into it because we've got a lot to get through this afternoon. And I'm going to introduce Dr. James Ding, who's going to give some welcome remarks. James Ding is Commissioner of Inclusive Dispute Avoidance and Resolution Office at the Department of Justice. Upstairs or upstairs? Just upstairs. He'll be able to join us for a short time, but not for the entire sessions. But Dr. Ding, thank you very much for coming. Over to you. Thank you.
Thank you. Dr. Lee Hu, Vice Chairman of CMAC, Mr. Arbitration President, Hong Kong Maritime Arbitration Group, distinguished guests, ladies and gentlemen. First of all, I would like to express my appreciations to CMAC, the Hong Kong MAC, Hong Kong Maritime Law Associations, Hong Kong Institute of Arbitrators, and the Charter Institute of Arbitrators East Asia Branch for the opportunity to speak this afternoon. The mock arbitrations used to be held during the Hong Kong Maritime Week. However, owing to the COVID-19 situations, the Hong Kong Maritime Week was cancelled this year. Despite the cancellation of Hong Kong Maritime Week, I'm glad that we are still going ahead with these 2020 editions of the mock arbitrations, not only physically, but also via the internet. In fact, the COVID-19 pandemic has not only presented challenges and uncertainties to Hong Kong, but also to any other part of the world. We must make the best use of our capabilities and expertise, including in the field of maritime arbitrations, to tackle the uncertainties and challenges. We remain committed to consolidating and enhancing Hong Kong's positions as an international maritime center. In the field of maritime arbitrations, I would like to share with you a piece of encouraging news that most of you should probably be aware of. The Baltic and International Maritime Council, BIMCO, has recently included Hong Kong as one of the 4 arbitration options under the BIMCO Law and Arbitration Codes. BIMCO is the world's largest direct membership organization for ship owners, charterers, shipbrokers, and agents, and the leading organizations responsible for developing standard contracts for the shipping industry. The decisions of BIMCO is a vote of confidence and recognition of Hong Kong as an efficient and effective venue for resolution of maritime disputes. This outcome is a result of the joint efforts in promoting maritime arbitrations by Hong Kong MAC, Hong Kong Shipowner Associations, our practitioners, and various government departments over the past years. The new BIMCO Law and Arbitration Codes 2020 incorporates the specific provisions of each venue for user selections and also includes new and useful provisions relating to the serving of notices. Among other things, the Hong Kong versions of BIMCO Code states that the seat of arbitration shall be Hong Kong and the arbitration shall be conducted in accordance with the Hong Kong MAC terms. This is also a significant development for Hong Kong MAC, which was established in 2000 and became an independent institution in October 2019, formed by a group of maritime professionals of diverse backgrounds, expertise, and industry experience with the aim of promoting the use of maritime arbitrations and mediations in Hong Kong. We hope that this latest development will help attract more maritime arbitrations to be conducted in Hong Kong, enhancing its status as an international legal hub for legal, dealmaking, and dispute resolution services. Apart from the above international developments, I would also like to share with you some developments in this region. Under the principle of one country, two systems, the mainland and Hong Kong are different legal jurisdictions. Arbitral awards rendered in the mainland and Hong Kong are mutually enforceable pursuant to the arrangements concerning mutual enforcement of arbitral awards between the mainland and Hong Kong. At the moment, we are in the process of reviewing the arrangements to explore ways to further facilitate enforcement of arbitral awards between the mainland and Hong Kong. For example, clarifying the scope of the arrangement, covering recognitions of awards, pre- and post-award preservation measures, allowing simultaneous enforcement under the arrangements, and bring it more in line with the seats of arbitration approach. In addition, the arrangements concerning mutual assistance in court order interim measures in aid of arbitral proceedings by the court of the mainland and of the Hong Kong SAR came into effect on the 1st of October 2019. Hong Kong became the first and only jurisdictions outside the mainland where mainland courts can grant interim measures in aid of an arbitration seated in Hong Kong and administered by an eligible institution. The first application under the arrangement was an application filed by a party to an arbitration administered by an eligible arbitral institution in Hong Kong. The application was heard and granted on the same day by the Shanghai Maritime Court on the 8th of October 2019. The arrangement has been very well received by the arbitration community, which generally consider that it will help enhance the attractiveness of Hong Kong as a seat of arbitrations for mainland-related disputes. Further, the Department of Justice has been pursuing various initiatives in the Guangdong, Hong Kong, Macau, Greater Bay Area to seek further liberalizations, allowing the parties in the Greater Bay Area to choose Hong Kong law as applicable law and Hong Kong as the seat of arbitrations in their contracts, even in the absence of foreign-related elements. Such measures will provide more options to the parties and help promote legal and dispute resolution service of Hong Kong. While some progress has been made in relation to the initiative on applicable law in Qianhai, we will continue to liaise with the mainland authorities to pursue such initiative in the Greater Bay Area. Now, turning to the cases today, both disputes in the mock arbitrations are related to COVID-19. The mock arbitrations will also be conducted online in light of COVID-19 pandemic. Indeed, COVID-19 has provided important stimulus into the development of online dispute resolutions (ODR) in these regions and internationally. During the pandemic earlier this year, in April, Hong Kong, China opted into the APEC collaborative framework for online dispute resolutions of cross-border business-to-business disputes, which is an optional framework developed and endorsed by the APEC Economic Committee to help businesses, especially micro, small, and medium-sized enterprises (MSMEs), to resolve cross-border disputes through an effective and efficient online platform comprising negotiations, mediations, and arbitrations. In line with the APEC ODR framework, and in anticipation of an upsurge of disputes arising from or relating to COVID-19, the government introduced the COVID-19 ODR schemes to provide the general public and the businesses, particularly MSME, speedy and cost-effective means to resolve low-value disputes through negotiations, mediations, and arbitrations. The scheme, operated independently by EBAM Center, aims to provide speedy and cost-effective means to resolve disputes, especially those involving MSMEs that may be adversely affected or hard hit by the pandemic. The process to be adopted is a multi-tier dispute resolution mechanism, where the parties will first attempt to negotiate the disputes in 3 days, followed by mediations in another 3 days, and if that still does not result in settlements, followed by arbitrations in 7 days for a final and binding award. The schemes cover disputes arising out of or in relation to the COVID-19 outbreak directly or indirectly. Either one of the parties is a Hong Kong resident or company, and the claim amount is below $500,000 Hong Kong dollars. Under the scheme, each party to the dispute is only required to pay 200 Hong Kong dollars as registration fees. The mediator and arbitrator fees will be borne by the government. Not only can the scheme prevent entrenched views on conflicts, relieve the court caseload in civil claims accumulated, and help foster harmony in society, it also brings the benefit of job creations and job advancement for the legal and dispute resolution sector, enabling them to learn how to handle cases online and under social distancing measures. To conclude, let me reiterate that the adverse economic impact of COVID-19 pandemic on global businesses will undoubtedly lead to a rise in the need for resolution of cross-border disputes, and online dispute resolutions will likely become more and more common. In order to equip the professions with the ability to make good use of modern technology and handling online dispute resolutions, capacity building and training is very important. Earlier this year in Hong Kong, we have seen that the virtual Risk is Moot and ICC mediation competitions were all conducted completely online with the support of Event Center, which contribute to capacity building and training for students and professionals in different parts of the world. The feedback from the participants are overwhelmingly positive. Similarly, this year's mock arbitrations will also be conducted virtually for the first time. I believe that this event will further contribute to our capacity building efforts, which will benefit Hong Kong and beyond. Lastly, I wish this event every success, and I look forward to seeing the event again in the Hong Kong Maritime Week next year. Thank you very much.
Thank you very much, Dr. Lee. More great support from the government, from the Department of Justice. We do appreciate the work that you're putting into the promotion of arbitration, promotion of dispute resolution, and you've listed quite a number of the issues that you're working on at the moment. Thank you very much for your support and your help with those. I now turn to our second keynote speaker, who is Dr. Hu Li. I see you on the screen, and I think you're ready to go. He is the Vice Chairman of the China Maritime Arbitration Commission, CMAC. Dr. Hu Li, please.
Thank you, moderator. Dear Dr. John Dean, dear guests, dear friends, ladies and gentlemen, good afternoon. I'm very happy to see some words in today's event. Let's look at the whole picture of international dispute resolution. In general, the cross-border disputes are inevitable involved with different legal systems and different rules of law, both procedural and substantive. The parties may, in the first place, seek to prevent disputes. So the dispute prevention is likely to be chosen as a priority of parties. Along with the coming forth of the Singapore Convention on Mediation, the status agreement from the international mediation can be enforced in the Convention state. The future of the ADR is promising that the Convention has enabled possible the parallel development of mediation, arbitration, and resolution. However, in my mind, arbitration is still going to be adopted as the main dispute resolution mechanism. Mediation results in the settlement agreement, which is promise between both parties. Arbitration should be conducted strictly according to the applicable rules and the special agreement of parties, and end with a final award of the arbitrator. The role of arbitrator award cannot be replaced by the parties' settlement agreement, and the arbitration cannot be awarded by the mediation. So the arbitration has its own special value in dispute resolution. As both parties, they may flexibly do the best to prevent disputes, and for the resolution domestic or local dispute, we may consider local litigation for the convenience of enforcement judgment. For cross-border disputes, the arbitration or mediation is proposed to be adopted with the overseas enforcement of the award or settlement agreement. The parties may decide to choose arbitration or mediation upon differences and advantages of them, considering the specific circumstances of the cases. Alternatively, the parties may also choose a mediation first, followed by arbitration, or according to the arbitration clause in the settlement agreement. In the field of arbitration, the maritime arbitration has its long history, and Hong Kong is an important international seat for maritime arbitration. The China Maritime Arbitration Convention STIMA established its Hong Kong Object Center in 2014 with the support of the Department of Justice of Hong Kong SAO. STIMA was founded in 1959 and is only one maritime arbitration institution in mainland China. STIMA has accepted 243 cases, including 84 international ones, since 2018. So the case levels of international cases accounts for 30% of the total case level to STIMA. In the past few years, the relevant efforts have been undertaken by STIMA to perfect its arbitration under the framework of Embedded Railroad Initiative. We are widely strengthening cooperation with international legal institutions, actively exploring and promoting to establish bilateral and multilateral disputes resolution platform by which the listed institutions may promote together while providing their legal services respectively if and when choosing the parties. In the meantime, our panel of arbitrators were updated in 2017 to include more and more former arbitrators and arbitrators from Hong Kong, Macau, and Taiwan for the convenience of foreign parties. And our arbitration rules were amended once again in 2018 to adopt the best practice of international arbitration. All these measures in return give a push for STIMA's further internationalization. And in order to formulate a flexible legal mechanism and better serve the best involved initiative, the Supreme People's Court of the Republic of China has established two Chinese International Commercial Court, CICC, in Shenzhen and Guangdong Province and Xi'an of the Shanxi Province respectively, as one International Council for Commercial Exports, NCCE. According to CICC's rules of procedure, which has come into force since 5th December 2018, SPC has included Xi'an in SPC's panel of arbitration and conciliation institutions, so that for the relevant international arbitrations conducted by Xi'an, the parties may enjoy direct support from the SPC for reviewing jurisdiction, granting interim measures, and setting aside enforcing award. This will both demonstrate and enhance Xi'an's credibility. The conduct of international arbitration is likely to be very different following COVID-19 pandemic. The major international arbitration institutions give a wide discretion to arbitrators as to how an arbitration to be conducted. Xi'an, in addition to pure online arbitration, has also formulated the guidelines for virtual oral hearings in arbitration. The arbitral procedures are therefore already available for the conduct of virtual hearings. We are happy to see that Hong Kong has been appointed by the BIMCO as one of the 4 arbitral seats in the Law and Arbitration Clause 2020. Xi'an Hong Kong Center is willing to cooperate with Hong Kong Maritime Arbitration Group, Hong Kong Maritime Law Association, Hong Kong Institute of Arbitration, the Chartered Institute of Arbitrators, as well as Hong Kong arbitration community, and promote Hong Kong as the international seat of maritime arbitration, and provide high quality and efficient services for maritime arbitrations with the seat in Hong Kong. I also want to thank my colleagues of CIMAC Hong Kong for their excellent work on the event. I wish today's mock arbitration a great success. Thank you. Thank you very much.
Dr. Hooley. Hello. Yeah, Dr. Hooley, thank you very much for your welcome address. It's very much appreciated. I don't know which way you can see me better, maybe this way. You mentioned a number of issues, but one I think that resonates is the virtual hearing, the virtual arbitrations, and certainly I believe we're all getting quite used to those. A number of procedures have been drawn up, people really know how they work, and as we go into the future I can see more of that happening, and less travel for witnesses and arbitrators around the world. Okay, we now move into substantive part of our afternoon. And Kai, welcome to the stage. There are 2 arbitrators here, and then we have 1 arbitrator online. Mr. Edward Alder is the chairman of the tribunal. Everybody knows Edward, I'm sure. And then we have here Mr. Bill Amos, one of his co-arbitrators. And the other co-arbitrator is Mr. Kai-Boon Zhao, Jingtian Gongchen. Are you online? Do you have our 3rd arbitrator online?
Yes.
Okay, yes, he's online. That's good. Maybe you need to open that up so people can see our 3 arbitrators. So I'm going to hand over to our chairman of the panel. You've all had the notes, you've all read through the notes, you know what the arbitrations are about, but I'm sure as we get into it, the parties themselves will explain their positions in greater detail. Can I invite the parties to come up and take their seats? Then I turn over to the chairman. Thank you, Mr.
Thank you. Yeah, good afternoon, everybody, and welcome to the arbitral proceedings. Now, give counsel a moment to prepare. Right, good afternoon, counsel, and welcome to this hearing. As you know, my name is Edward Alder. I'm the presiding arbitrator today. To my left is Mr. Bill Amos, and this, as you know, is partially a virtual hearing because the 3rd arbitrator, Mr. Cho, is joining us online. I would invite counsel for the parties to introduce themselves.
Good afternoon, members of the tribunal. My name is Eunice Bai. I'm counsel for the claimant in this case. The claimant is the owner of the vessel called Seajewel. This is the owner's application for an order that the respondent, the charterers, to provide security for the claimant's costs in defending the respondent's counterclaims.
Thank you. And I'll ask counsel for the respondent to introduce themselves.
Good afternoon, members of the tribunal. My name is Cindy Ko from Speakers and Howard, appearing on behalf of the respondent in this case and respondent to the application. And with me today, I have a colleague, Mr. Henry Yeo.
Thank you. Unless there's anything from either of the tribunal members, I think we can begin with the applicant's submissions.
Thanks, sir. Before I start, let me give you copies of a case that I'm going to refer to in my submission. I'll start with my application now. So first, I submit that the tribunal has the power to order security for costs. The seat of this arbitration is Hong Kong, and as such, the powers of the arbitral tribunal derived from the Hong Kong Arbitration Ordinance. There is no doubt that the Hong Kong Arbitration Ordinance explicitly authorizes the tribunal to make orders in respect of security for costs. In that regard, I refer the tribunal to Section 56, Paragraph 1, Subparagraph A of the Hong Kong Arbitration Ordinance, which provides that arbitral tribunals may make orders requiring a claimant to give security for costs of the arbitration. Now, this equally applies to a respondent in respect of its counterclaims, such as the charterers in this case. The tribunal also has the authority to grant wide-ranging measures of protections at the request of either party under the arbitration rules of China Maritime Arbitration Commission 2018 rules. I refer the tribunal to Article 27, subparagraph 2 of the CMAC rules, which provides that at the request of a party, the arbitration tribunal may decide to order or award any interim measures it deems necessary or proper in accordance with the applicable law or the agreement of the parties. So in short, it is clear that the tribunal has the power to make orders granting security for costs under both the Hong Kong Arbitration Ordinance and the CMAC rules. For the reasons that I'm going to take you through, I submit that the tribunal should exercise that power in this case. While the ordinance and the CMAC rules empower the tribunal to make such orders, neither set out a specific test which the tribunal should apply. Therefore, the tribunal may have regard to external sources by way of guidance, as set out in case laws and leading arbitration textbook. The key consideration in our security for costs application is that whether the respondent in this case to the application will be unable to pay the claimant's costs if the counterclaim is unsuccessful, or put it differently, whether there will be any serious difficulties in enforcing an order for costs against the respondent. This test is set out in the leading Hong Kong arbitration textbook, named the Hong Kong Arbitration in Hong Kong, a Practical Guide, 3rd edition 2014. Now, in the present case, the claimant submit that there can be no doubt as to the chatter's impecuniosity. The claimant, as to the chatter's financial position, the claimant has invited the respondent on numerous occasions to comment and provide evidence to show that the respondent does have sufficient readily available assets to satisfy any order as to costs, but so far the chatterers have refused to comment. As a starting point, the respondent, the chatterers, does not publish its accounts, so there is very limited public information about the assets or financial situation of the respondent. Against this background, the claimant commissioned a third-party independent search firm to prepare a report regarding the respondent's asset position. Now let me take the tribunal through the findings of the report. The key findings are that, firstly, the charterers do not own any vessels. Secondly, despite being a Hong Kong incorporated company, the charterers do not have physical presence or assets in Hong Kong. Thirdly, although the respondent bears the company name Eastern Shipping Group, there is no public available information about the relationship between the respondent and the well-known group entity named Eastern Shipping Group. And the respondent's shareholder is actually a BVI company. There is also no known link between the respondent's sole shareholder to the Eastern Shipping Group entity. Now, this finding is relevant because this means that it is more likely than not that the respondent does not have available finance from its associated or controlling corporations and cannot call upon its parent company for financial resources. In this regard, I refer the tribunal to the decision of the UK Court of Appeal in Sapphire Oil International. Sorry, I don't have a copy of that case. In Sapphire Oil International versus Adex Energy SA, in which the court noted that it is common practice for security for costs to be granted against a company which is not obliged to publish public accounts, has no definable assets, and has declined to reveal any information about its financial position. This is exactly the situation here. Now, the claimant has done its best to obtain information about the respondent's financials by commissioning a third party's investigation report. Despite the claimant's multiple requests, the respondent, who is the only party that is able to provide such information, has so far declined to reveal any real information. All these strongly points that the respondent do not have sufficient assets to make any cost orders, and these are sufficient reasons for the tribunal to order security for costs against the respondent. Now, my learned friend might argue that the respondent's counterclaim is a mere repetition of its defense, and therefore security for costs should not be granted. As to this, it is true that the claims and counterclaims arise out of the same set of facts and transactions. The claimant's claim are for unpaid hire. The respondent's counterclaim are related to their entitlements to deductions from the hire. However, this fact alone does not prevent the tribunal from ordering security for costs against the respondents in respect of its counterclaims. In this situation, the principle established in cases such as Petromine versus Sacrinet, which I just gave the tribunal a copy of, and an earlier case, Samuel J. Cole versus Eastern Mediterranean Maritime. The principle set out in these case law is that security for costs will be ordered where the respondent would have prosecuted the counterclaim in any event, and it was mere chance who first commenced the arbitration as claimant. This is the case here. The respondent could equally have commenced the arbitration proceedings by seeking a declaration that they were entitled to make deductions from the hire for the quarantine period. And there's more. In addition to this declaration, the respondent, the charterers, sought damages for losses arising from the claimant's alleged breach of the charter party by failing to supply a seaworthy ship, which includes crew worthiness. The respondent in turn argued that the quarantine period could have been avoided otherwise. So it is clear, therefore, that the respondent's counterclaims have enlarged the ambit of the action in terms of issues, and therefore increased time and costs of the arbitration. Lastly, the claimant estimates its cost for defending the counterclaim to amount to $200,000 US. In light of the above, I submit that it is more likely than not that the charterers will be unable to pay the claimant's costs if the counterclaim is unsuccessful. Under Section 46 of the Hong Kong Arbitration Ordinance, the tribunal has an overriding duty to ensure equal treatment of the parties so as to provide a fair means for resolving the dispute. In this case, granting an order for security for costs is consistent with that overriding order, with that overriding duty. It will be unfair for the claimant to be forced to expend considerable sums in defending the counterclaims in circumstances where there is no prospect of the claimant being able to enforce and recover those amounts from the respondent in the event that the counterclaims are dismissed. Therefore, the granting of this application would accord fully with the tribunal's general duties under both the CMAC rules and the ordinance. The claimants therefore request the tribunal to grant that order. This concludes my submission.
Thank you, Counsel. Mr. Joe, do you have any questions so far? Mr. Joe, do you have any questions? Okay. Ms. Raymond, do you have any questions?
No questions yet.
I have one question, and that's the function. No question. I understand that you're seeking $200,000 US of security.
Yeah.
That figure is to be found in your questionnaire.
Yes.
Do you say that's the costs of the entire arbitration or just of dealing with the counterclaim?
It's just the dealing with the counterclaim.
All right, I see. Well, we'll take that to be the application. Can I ask Counsel for the respondents to make their submissions?
Good afternoon, members of the tribunal. Appearing on behalf of the respondent today, we resist the application for security for costs of defending the counterclaim. So, my other friend has taken you to some of the main facts, so I will not have to run through them at this juncture. But I think at the outset, we would say that the respondent agrees that the tribunal has the power to order security for costs, so that jurisdictional aspect is not disputed. Then we come on to the substantive application for security for costs and the applicable tests to be applied. I think my learned friend has also considered that the security for costs is meant to protect against expenses that a defendant, in each case, will have to be put through in defending a claim or a counterclaim. And so we will submit that the considerations which the tribunal should have in mind are first, whether there are in fact any grounds to show that the respondent here does not have assets to meet any adverse cost orders should the counterclaim be unsuccessful. And second, whether in light of the nature of the claims and counterclaims, it is true that the applicant, being the defendant in the counterclaim, will be put to additional expense in defending the counterclaim. And on both of these, the respondent submits that the tribunal should not grant an order for security for costs. I will address each of these in turn. So to begin with the argument that the applicant has made to say that the respondent does not have any assets to meet any potential cost orders, we submit that the applicant has not discharged its burden of proof to show that we do not have these financial means. The tribunal will note that the main document that the applicant is relying on is the report which it has commissioned to show that the respondent has no assets. At the outset, we will say that this report is somewhat self-serving, having been commissioned for this particular purpose. So we ask the tribunal to exercise some caution when taking this into account. So to address each of the allegations which my learned friend says the asset search report shows, as to the first point that the charterers do not own any vessels, I think this submission is really a misunderstanding of the shipping industry and the charterers' business. The question here is whether the charterers have any assets, and assets are not limited to ownership of vessels. In respect of a chartering business, charterers' assets are charter hire that are receivable, and these are also considered to be assets. So to rely solely on the fact that charterers have no vessels and say that charterers have no assets is clearly incorrect. On the second point, I think my learned friend has also relied on the allegation of a lack of physical presence or assets in Hong Kong. In the context of an arbitration, the actual location of assets is less relevant as compared to where we are dealing with the court application. So on this note, we would say that the charterers have assets and the fact that they are not located in Hong Kong is not relevant. On the third point, my learned friend has submitted that there is a lack of connection between the respondent and the Eastern Shipping Group. We would submit that this is inconclusive because each company in the group is a separate legal entity. So whether there is a connection between charterers and the group is irrelevant to charterers' own financial means to meet any cost orders. Finally, on their allegation that there is a lack of published accounts and public information about the charterers' assets, this is somewhat misconceived. The respondent charterers here are a private company, and we do not need to publish our information on the assets. I think the fact that the applicant is making this argument only shows that we do not have any evidence to show that we don't have any assets. We'll just remind the tribunal that it is the applicant who bears the burden of proof in this case to show that we have no assets. And it's not for them to just make an assertion that there are no assets and then invite us to show them evidence that we have assets. This is reversing the burden of proof in this case. So for reasons that I have set out above, we submit that on this first argument, the applicant has not discharged its burden of proof to show that the respondent has no financial means to meet any cost orders that may be ordered. I'll now move on to my second point, which is to deal with the argument that in light of the nature of the claim and the counterclaim in this case, and the fact that the counterclaim is essentially a defense to the claim, security for costs should not be ordered. If we just put things into perspective, this application here is an application for security for costs of defending counterclaim, as opposed to a usual application for security for costs of claim. And because of this, we say that the tribunal should exercise its discretion in a cautious manner. The test here, I think, is whether the applicant will be put to the expense of having to defend a counterclaim at the risk of not being able to recover costs for a potentially unsuccessful counterclaim. And to this end, we say that if in fact the issues in the claim and the counterclaim are very, very similar, so that the counterclaim is essentially a defense to the claim, then the applicant cannot say that it is being put to a further expense and there is a risk that these expenses will not be met at the end of the day. If I can just bring members of the tribunal back to the nature of the claim and the counterclaim in this case. The claim here is for unpaid hire, and the counterclaim here substantially is for declaration of entitlement to deduct hire. Of course, there is an additional claim for damages, but we say that that is a small portion of the claim, and substantially the counterclaim is for the defense that they are entitled to set off hire. So, we say that the applicant will not be put to any more expense than it would if it had been pursuing its claim. And the applicant cannot use this means as a backdoor to get the respondent to fund the applicant's claim. The lawyer has also made the submission as to what the tribunal should do when the claim and the counterclaim arise out of the same facts, and they say it is just by a matter of chance as to who commenced the action first. I would say that in this case, in light of the facts, the tribunal will be aware of the circumstances leading to the commencement of the arbitration. Parties had agreed to put a certain sum into escrow and then start these proceedings. And I would say that because of this background, little weight can be put, if any, to the factor of who had commenced the arbitration first, or whether the respondent would have commenced the arbitration in either case. And I think I will just move on to deal with this case that my learned friend has cited on Petromin, where they said that even if the claim and the counterclaim arise on the same facts, security for costs can be awarded for defense of the counterclaim. I think it is somewhat overly simplistic if we just take it from the case that if the claim and the counterclaim arise from the same facts, security for costs can still be ordered. The respondent will submit that the tribunal should consider the nature of the claim and the counterclaim, and whether it arises from the same facts is just one portion of this analysis. And I will point the tribunal to a certain paragraph in Petromin. If your sirs have the case before you, this is at page 606, column 2. And while the tribunal looks for this paragraph, I will just refresh again the facts of this case. In Petromin, the case involved the bareboat charterer. The defendant's charterers alleged that the plaintiff was in repudiatory breach of the bareboat charter because they failed to give the defendant's surveyor a reasonable opportunity to inspect the vessel, and they insisted on only obtaining equipment from the plaintiff's nominated suppliers. And because of these alleged breaches, they terminated the charter party. The plaintiff claims that the defendant's termination was wrongful, and so the plaintiff relied on that to terminate the charter party. The defendant then also said that the plaintiff's termination was wrongful, and relied on this as a further ground to say that the defendant was in breach of the bareboat charter. So at the end of the day, what was before the tribunal was the plaintiff's claim and the defendant's counterclaim. The plaintiff's claim is for a declaration that its termination was lawful, and then damages resulting from the defendant's breach. On the other hand, the defendant's claim is for damages for the plaintiff's breach. And so, if we look at what the judge said about the nature of the two claims at page 606, column 2, somewhere around 2/3 of the page, it says that both parties have made substantive claims based on the same facts, and either could probably have been the claimant. The counterclaim was not merely a defense directed to smothering the plaintiff's claim by a set-off. It was a large claim for damages in its own right. So, if we analyze the facts of Petromin, it is somewhat different from the facts we have on hand. So in Petromin, it was, even though the claims were based on the same set of facts, each of them were being advanced as a substantive claim for damages. I'll direct your honor to another case which I think is factually more similar, and this is the case of Hitachi and Biafra, which my colleague will now hand copies to the tribunal. In this case, Hitachi and Biafra, the factual dispute arose out of three contracts for building three different ships. The builders sued the buyers for wrongful repudiations, and the buyers counterclaim on the ground that, amongst others, the ship could not have been delivered in accordance with the contract. So the buyers here sought a claim for damages arising out of this ship's failure to be delivered. And when dealing with the application for security for cause of the counterclaim, the judge in fact declined to order any security because on an analysis of the claim and the counterclaim, the court felt that the claim and the counterclaim stand and fell together on the same facts. And so if the termination was correct, then the builders would be correct. And if the termination was wrongful, then the buyers would be correct. And their claim for damages only results from the main claim. So if we analyze this, the nature of the counterclaim in Hitachi comprises two portions. One, essentially a defense of the claim on the issue of termination, and then only if the buyers are correct on this issue, then their claim for damages results therefrom. So I think it is this factual distinction that makes Hitachi somewhat more relevant to our case. Because if members of the tribunal recall, the counterclaim here, as I explained earlier, can be split into two portions. The first being a declaration that the vessel was in fact off hire, and then only after that, then a claim for damages for breach. So I think this is one point of distinction which therefore puts my learned friend's reliance on Petromine to be quite incorrect in this case. And I will just point out one other difference in this case between Petromine and our present case. In Petromine, the party against whom security was sought did not actually make any argument as to whether security should or should not be granted in light of the nature of the claim and counterclaim. I think the main arguments in that case dealt with whether the defendant had the means to meet any cost order or whether any order for security for cost would stifle the main claim. So there's another difference. And in light of the fact that in Petromine, both parties were essentially putting up a substantive claim, the claimant had, in that case, on their facts, already agreed that they would put up security for their claim. So all of this is quite different from the present case, and I would urge the tribunal to place less importance on this case of Petromine that has been relied on by my learned friend. So the respondent's submissions, therefore, is that first, the applicant has not discharged its burden of proof to show that the respondent does not have assets to meet any potential cost orders. And second, in light of the nature of the claim and the counterclaim in this case, the applicant is in fact not put to any additional expense of having to defend the counterclaim, and so security for cost should not be granted. But it is the respondent's alternative case that if the tribunal is minded to make any order for security for cost, this amount should only be for a nominal sum representing the work that has to be done arising out of the counterclaim. And this is, as we explained earlier, just a very negligible amount being the claim for damages that results. I think just to clarify with my learned friend, she had said earlier that 200,000 relates to the amount for the counterclaim only, but I think in the parties' questionnaire they had both indicated around 200,000 for the entire claim. So we would submit that out of this 200,000, which is to do with the entire claim, only a very small amount deals with the counterclaim. And having this in mind, if the tribunal is minded to make any order for security for cost of defending the counterclaim, the respondent would submit that a very small amount should be ordered and perhaps around $15,000. Support for this can be seen in the case of Hitachi, where the court eventually did not grant any security for cost of the counterclaim. But the court said that even if any were to be granted, it would be limited to the amount which reflects the additional cost of investigating and contesting the amount of damages claimed. And in this case, we would say there are no additional factual issues which arise from the claim for damages. If any, it would just be a small portion of additional legal arguments. So in light of this, it is the respondent's alternative submission that if the tribunal is minded to grant any security for cost, it should be for a nominal amount. Unless I can be of any further assistance to the members of the tribunal, these are my submissions for the respondent.
Yes, Ms. Coe, just one question, and this may be from Ms. Bai as well. It's a question relating to the financial test that we have to apply. Now, obviously, this is an arbitration, not a court proceeding. We note that the respondent charterers are a Hong Kong company. Does the Hong Kong Companies Ordinance provisions relating to security for costs, are they of any relevance to this application, or should we ignore them?
From the top of my head, I remember the Hong Kong Companies Ordinance contains some provisions about security for costs in the situation where the company is insolvent or bankrupt. And I remember there are some high court rules about that, but I think that's not the situation in this case for the respondent. I'm happy to make further submissions on this issue after this hearing.
Thank you.
I don't have anything further to add unless we will read any submissions they have and then respond to them accordingly.
Thank you.
I have a question for either side. Perhaps my opinion, my observation about the security sought from the claimant is quite different. There's a huge gap between the $200,000 US and the $15,000 US, which might interest the audience to know why the gap is coming from, and then why the claimant want to cover the whole arbitration costs, and the other side may say different.
The claimant are claiming for the entire cost of the arbitration, which is $200,000. I think Marlon Friend's position is that a large part of the cost claim is only a repetition of the defense, and therefore their position, which I do not agree, is that we're only entitled to the cost in relation to the additional counterclaim, which is not exactly a mirror of the defense, which they claim to amount only to $15,000 US.
Yeah, if I could just add to that, I think at the end of the day, it boils down to an analysis of the nature of the claim and the counterclaim, and the two different factual situations in the cases that have been cited to the members of the tribunal. So in the first case, Benjamin, where each of them, although premised on the same facts, are independent claims in their own right, the court said that each party should bear the full cost of, put up security for the full cost of the arbitration, because there is no difference in that both are independent claims. Whereas in Hitachi, the court said that the nature of the counterclaim is such that the bulk of it is just a defense of the main claim, and the additional portion, substantive claim for damages, is only small amount, and so security that should be ordered should only be for a lesser amount. And the respondent's submission is that the facts of this case are more similar to that in Hitachi, and therefore we should follow the court's comments that were made in that case.
Thank you, counsels. Thank you, Mr. Zhou. Fran, do you have any reply?
Yes, thanks, members of the tribunal, thanks, Brad. I'll deal with the respondent's rebuttal points in turn. First, the respondent claims that the claimant has not discharged its burden of proof, that the respondent has no financial means to meet any cost orders. In particular, Madam Friend criticized our reliance on the asset report produced by an independent search firm. Now, to deal with each of these criticisms in turn, my learned friend criticized this report being self-serving, but there is no reason to believe that the asset report has not accurately set out the results of the investigation conducted by the independent search firm. In fact, the respondent has offered no evidence to prove any of the findings in the report is inaccurate, even though they are the party who has all the relevant information and have had plenty of opportunities to do so. Now, the proper inference from this is that the findings in the report are simply accurate, and the respondent cannot mount any credible challenges against these findings. Secondly, the lack of physical assets, such as vessels, is certainly a factor in a security for costs application, even though the respondent might have charter hires or receivables. It is possible that such assets are balanced by corresponding liabilities, which we have no insight into. In fact, the respondent has provided no information as to their assets or liabilities. My then friend also saying that the fact that there is no asset in Hong Kong is not relevant. But I think that the question here is whether there are assets that are readily available to satisfy any orders. If there are assets in Hong Kong, then arguably these would be readily available for any enforcement. But hidden assets in unnamed jurisdictions or jurisdictions in which a Hong Kong arbitration award cannot be enforced are not readily available, and we haven't been given any information about these assets either. My next point is that contrary to the respondent's assertions, lack of connection to a well-known shipping group is certainly relevant. I note the respondent does not deny that they are not related to Eastern Shipping Group. The fact that the respondent is not an entity within this shipping group, which owns vessels and shares in vessel holding entities, makes it, on the balance of probabilities, unlikely that the respondent have available finance from its associated or controlling entities or can call upon its parent company for financial backup. In summary, I submit that the claimant has discharged its burden of proof by producing the asset report of the third-party independent search firm, which has shown that it is more likely than not that the respondent does not have substantial assets and has no financial means to meet any cost orders. Whilst the respondent has criticized the claimant's reliance on the asset report, they have not otherwise proved that the findings of the report are in some way misleading or that the respondent does have sufficiently available assets. There is nothing in evidence that can be given more weight than the asset report. I refer the tribunal again to the decision of the UK Court of Appeal in Sapphire Oil International versus Alex Energy, in which the court noted that in this scenario, it's common practice for security for costs to be granted against a company like the respondent, which has no discernible assets and has declined to reveal any information about its financial position. Next, I'll deal with the respondent's point about the nature and the overlapping between claims and counterclaims. Firstly, cases including Patrolman versus Sapphire, as well as Samuel J. Cole versus Eastern Mediterranean Maritime, all confirmed that the court has discretion to award security even in cases where the counterclaim arose out of the same facts. Now, my late friend relied on the Hitachi case. I think the different approaches in Hitachi and Patrolman, which I relied on, the key questions turns on whether the respondent should merely be treated as the defendants to the claim, which is the Hitachi case, or whether both parties are substantial claimants founding their claims on the same body of facts. And that's the Patrolman case, which I relied on. And I submit this current case is the latter situation, i.e. both parties are substantial claimants founding their claims on the same body of facts. As mentioned, it is our view that the respondents could have equally commenced the proceedings by themselves, seeking a declaration as to their entitlement to the deduction from hire. They have this additional counterclaim for loss arising from the owner's alleged failure to supply a seaworthy ship. Therefore, the counterclaims raised by the respondent in this case is not merely a defense meant to set off the claimant's claims. Instead, they are the real claimants in terms of the counterclaims. And in that case, Patrolman versus Sapphire should apply, and the Hitachi case should be distinguished. Conversely, if the respondent's position is that their counterclaim is a mere repetition of the defense, then they are free to withdraw their counterclaims and simply defend the claims so as to avoid the need to give security for costs. It would not be just and fair to permit the respondent to put forward any insubstantive counterclaims that merely repeats their defenses. The counterclaims should either have substance so that security should be provided, or they are not necessary and should be withdrawn to avoid any wasted costs. Finally, it is true that both Petromine versus Sakharnev and Samuel J versus Eastern Mediterranean were granted, in those cases, mutual security were granted as the court took the view that both parties should be treated alike. Now, if the respondent so requests, I confirm that to the extent that the respondent put up security for costs, the claimant will do the same. Finally, as to the function of the security, it is incorrect for the respondent to assert that the claimant should be limited to security only for additional expense to defend the counterclaims. The same argument was raised and rejected in Petromine versus Sakharnev. In his reasons, Judge Coleman explained that the fact that a respondent is mounting a counterclaim which arises out of the same facts as a claim does not mean the respondent only has to give security for the extra costs. It is different from the scenario where the plaintiffs and defendants are advancing claims based on different bodies of fact, where it makes sense for security for costs of the counterclaim to be quantified by reference to the additional costs that the plaintiff will incur in defending the counterclaims. The judge considered that in the case where both parties are substantial claimants funding their claims based on the same body of facts, as in this case, so that if the claim fails, the counterclaim will succeed, there can be no basis for adopting such a quantification of the security for costs of the counterclaim. The correct approach, as recognized by the judge, should be that the claimant is entitled to be secured in respect of costs not less than if he were merely defendant to the claims advanced in a counterclaim. This concludes my reply to the respondent's submission.
Thank you, counsel. Mr. Joe, do you have any questions for counsel?
I have any question right now.
Thank you.
Thank you.
I have one question, and this is about the report that you have commissioned and filed for the purposes of this application. Is there anything in that report that you could not have found out in the first place when your clients decided to contract with this charterer, or is there anything new in it that has arisen after the entry into the charter party, or indeed after the commencement of the arbitration?
As mentioned, when we entered into this charter party, there's really very limited public information about this company because it doesn't publish any accounts. But at the time, we didn't find the need to do sort of like a forensic investigation into the asset position of the charterers. It was only now, when we come into this arbitration, that we decided to engage this third-party search firms. So the information was not available to our clients before.
Thank you. Ms. Ferris, have you got any questions? Well, thank you, counsel, for your submissions. The tribunal would now, in a situation like this, either reserve their decision and give it on another day, or in a matter that's fairly self-contained like this, the tribunal might go to their breakout room and discuss the submissions and reach a collective decision and come out and announce that decision to the parties. So I want you all to assume that we, my fellow arbitrators and I, have been outside and discussed the matter and come back, and we've decided that Mr. Amos is going to give a decision and some very brief reasons.
Thank you for suspending disbelief. This was an application by owners for security for their costs of defending a counterclaim brought by charterers. It was common ground that the tribunal had jurisdiction to award security. The test was also common ground, and the first issue for us as the tribunal was whether there is reason to believe that the charterers will be unable to pay owners' costs if owners succeed in defeating the counterclaim. If we answer yes to that financial question, so if we find that charterers are without means, then we move on to consider whether in all the circumstances it would be just for us to exercise our discretion and order security. So, on the financial question, very briefly, owners have to satisfy a very high threshold. And, as Council pointed out, they do not have access to charterers' financial statements. Owners rely on a number of factors. We're told that charterers don't have any vessels or fixed assets. Well, as we just saw from the answer to the question, that was known at the outset, and it's perfectly normal for a chartering company not to own vessels. We're also told that they have a BVI company as a shareholder. Well, again, an offshore shareholder is not conclusive in showing that the charterers will be unable to pay. And then we're told, well, they're charterers. They only have receivables and freight payments. But again, receivables and freight payments are assets, and there's no suggestion that charterers are going to deliberately fold themselves in order to dishonour any award for costs made against them. So, in conclusion, the tribunal is not persuaded that charterers will be unable to pay owners' costs. So the application for security is dismissed with charterers' costs in any event. And lastly, and most importantly, we thank Ms. Bai and Ms. Coe for their very able and helpful submissions.
Thank you.
Thank you.
Thank you.
Thanks.
The decision.
That's a good thing.
Yeah, we'll get the decision copy with this. Thank you. Applications for security costs. Successful application security costs are quite rare, certainly in my experience. I've seen more turned down than granted. The barriers are really very high, as Bill Engels pointed out, as the tribunal pointed out. The barriers are very high for the owners to persuade the tribunal. So, do we have any questions about the procedural hearing that we just heard? In the room, everybody's very quiet. I'm missing a small trends here. Do we have anybody on Zoom putting questions in? Oh, could I've been asked, just before we start, for those that are listening in, could you make sure that your microphones are on mute? If your microphones are on, then it's very difficult for other people to hear. I see that we have one comment there that the audio quality is very, very poor. Captain, I hope you can hear me. Type yes. Captain Starby can't hear me. Okay, Jack Beach, you've got a question. Microphone for Mr. Macar, please.
When you were explaining the reasons that you were giving, Mr. Arbitrator, you mentioned that the situation with regards to charters was already known to the owners that they don't have assets, and they entered into the business. How much of that did play in the decision that you have made?
Thank you. Perhaps if we're looking behind the scenes of the arbitration, amongst the arbitrators there was a fair degree of scepticism about, we're very cautious about interlocutory applications which can become very expensive in themselves. A security for cost application could conceivably incur costs equivalent to the eventual arbitration if it's on documents alone. So our concern would really be that the parties, particularly as this is a maritime arbitration of a limited value, that the parties should really get on with the arbitration proper in order to keep costs under control. But that was the unspoken motivation, I think.
Yeah, I'll just add to that. There's probably a difference between court litigation and arbitration here. With court litigation, somebody can come along and sue you at any time, and you haven't consented to be in a relationship with that person, and there's no reason why you should be exposed to that person suing you and then not being able to pay your costs at the end of the day. Arbitration is different because the relationship is inherently consensual. So you have decided to enter into commercial relations with that person in the first place. So, for example, there's no security for hire. Unless, there sometimes can be if you get a parent company guarantee, for example, but here there was no guarantee for hire. So these owners voluntarily entered into a relationship with this company, knowing the asset position, or they were able to find it out, but they were still willing to enter into a relationship that may result in large sums being outstanding. And disputes may well arise, and they chose arbitration to resolve those disputes. So to some extent, it's a risk that you always take in entering into a contract that has an arbitration clause. So that's probably one of the reasons why security for costs is much less common in arbitration than in court litigation.
Of course, then. Hello? I'm from there. Yeah, I'm back. Okay. And that, of course, determines whether you go to arbitration. Because there are so many instances where your party might not be the most reputable party, and you thought it was a good deal at the time when you signed the contract. And when a dispute arises, can you actually collect? And that's always a difficult thing. Okay, any other questions? Do we have anything on Zoom with questions? There's a lot of people attending, apparently. We've got 80 people on Zoom and 20 here. Pretty good. All right. When I said we move on to the substantive part, I meant we move on to the procedural part of the substantive part of the seminar. We're now about to move on to the substantive part of the seminar, which is the dispute, again, on COVID. And you've got the case synopsis in your notes, which is very interesting. Could I invite, please, the parties to come and take their seats? Oh, what? They're online.
One question online.
Sorry?
One question online.
All right. Oh, one question. Sorry, we have a question. Do we? Oh, there. This gives an impression if the charters are not with any assets, we should not engage in trade with them, because the arbitration will not request for security, which is not good owners. Mr. Alder.
Sorry, we haven't got the text for that.
Okay, so right up behind you. Can you see it? From Captain Goldberg.
I think we'd say, ideally, engage with charterers who have huge amounts of assets. If that's not possible, by all means, engage in trade with them. And when it comes to an arbitration, do it as swiftly and cost effectively as possible.
Yeah, and I'd just add to that there can be a change of circumstance. So it may be that when you are content to enter into a charter party with somebody and you're content to take a risk on payment on the basis of the information you get at the time. But circumstances change over the life of the contract and by the time you get to arbitration. So this line of thinking or this line of argument doesn't necessarily rule out security for costs, but it can make security for costs less likely when there's been no change from the time of contracting in the first place.
Very good, thank you.
I definitely agree with that because it's a multi-factor issue to consider. For the time being, for the specific to the current dispute we are talking about, it's just a decision for the such circumstances we faced with. So it really depends on the specific deal you are going to have or deal the party you are going to deal with. So there's no decisive trend or inclination of the tribunal, the arbitration or the judiciary courts.
Let's get some help.
Sorry, Brian, I think Mr. Old needs some help with the screen. Okay, we need to improve the sound quality, obviously. Right, okay, so are we ready?
Yes, I think we are. Now, do we have one set of counsel in the room and one set online?
For both here.
Both here? Oh, okay, good. Please come forward, yeah.
I'll hand over to you, Mr.
Yeah, thank you. Good afternoon, Council. I think you know Mr. Amos, Mr. Joe, and myself. So I'll ask Council to introduce themselves.
Thank you. Good afternoon, members of the tribunal. I'm Andrew Lee. Thank you. Good afternoon, members of the tribunal. I'm Andrew Lee, together with my colleague Andy Lee from Hilton and Hong Kong. And we are today acting for the claimant, which is the owner of the vessel, Third Wave, in this matter. Yeah, and
So, Mr. Lee, I think there's still not enough volume from you.
okay.
Sorry, that's better.
So we are here to act for the claimant, the owners of the vessel, Third Wave, in this matter.
Thank you, and Council.
I'm Jonathan Corley, and with me is my colleague, Mr. Arthur Lam. We're from Reed Smith, Richards Butler, and today we're acting on behalf of the respondents who are the charterers.
Very good. Well, if nobody has any preliminary issues, I'll ask the claimant to make opening submissions.
Thanks, Chair. I will start first with the factual background, and then I will ask my colleague Maggie Lee to continue with the elaboration of our submissions. Given the COVID-19 outbreak, of course, the tribunal has allowed us, with the parties' consent, to conduct today's hearing virtually by Zoom, which we are very grateful. So please let us know if you cannot hear us very clearly. In this matter, owners claim against charters for two items. First is for the loss and damages arising out of charter's breach of the absolute state port warranty and the charter party. And secondly, the indemnity for the crew's compensation and medical expenses against respondent in charters and the charter party. The brief factual background. On 21st July 2020, owners entered a voyage charter with charters. The loading port was Kalimantan, Indonesia. The charter contained an absolute safe port warranty and included the BIMCO infectious and contagious diseases clause for voyage charters. Prior to the scheduled change of the chief officer, the crews had not disembarked the vessel at any other ports of call. Pursuant to the collective test of the crew on 2nd August, all crews were tested to be not positive. So far, only the outgoing chief officer was tested positive, and the only external source of the virus appears to be the pilot at that port. The discharging port was Ningde, China. All the Chinese ports have the strict restriction for vessels and require for compulsory quarantine, especially for the vessel which has suspended or confirmed cases. On 8th August 2020, the second officer was found to have severe COVID-19 symptoms, and the vessel deviated to save the life of the second officer. The second officer was hospitalized for 1 month and suffered from reduced lung function. The second officer then sought employees' compensation under Employee Compensation Ordinance, Chapter 282, which was fully paid by owners under the collective bargaining agreement. Now owners seek recovery from charters for these damages. And now let Ms. Lee to continue with the arguments. Thank you.
Thank you, Edward. So the owners first admit that Kalimantan port is an unsafe port and that all losses arising from visiting the loading port would be on charter's account. May 1st, the chief officer was the only infected crew member, and through contacting trace exercise, we found that the chief officer only contacted the pilot in the loading port, who was found test positive for COVID-19 after the vessels departed the loading port. As Edward said, prior to the schedule change, the crew has not disembarked the vessels at other ports of call. Second, all crew were tested to be negative on the 2nd of August. In such circumstances, the only source of infections of the COVID-19 was the pilot of the loading port. And the second officer was subsequently found to have symptoms of the COVID-19, which shows the transmissions must have been due to the exposures at the loading port. Regarding the law on safe ports, the present charter parties contain an absolute safe port warranty. Charterers has an absolute safe port obligations to nominate a port that is prospectively safe at the time of nominations for the ship to reach, to use, and depart from. If it was prospectively unsafe, then charterers will be liable for both causations and consequences. The fact that the charterer did not know or know of knowing the port was unsafe at the relevant times makes no difference. And by the time that August 2020, the situation with COVID-19 became a pandemic is well known, so it doesn't really make a big difference about the knowledge of charterer that the loading ports whether the outbreak of the COVID-19. And the crux of the dispute is whether the port became unsafe because of the COVID-19. As the region Eastern City and the Poligori cases, a port can be unsafe if the vessels be exposed to danger. In principle, owners argue that if there's an outbreak of COVID-19 at the loading port, and this has endangered the health of the crew of the vessels, and with owners admit that the port is not safe. And this is a multifactorial situation that we have to consider when we determine whether a port is unsafe or not due to contagious disease. Factors will be considered, such as any delays will be suffered, the risk of infections to the vessel's crew, the risk of contact with the shore personnel, and any preventive or proactive measures in place at the port. And in short, to test whether the risk of contagion can be dealt by taking reasonable precautions at the loading port and what measures have been implemented by the loading port to protect the crew from the threat of the contagion. To put it in another way, if the precautions put in place by the infected port are not sufficiently protective, the owners argue that the loading port is unsafe.
In this regard, the parties will be well advised to check ports of call for compliance with the IMO Circular number 4204. By this instrument, in issuing response to the COVID-19 pandemic, the IMO has, among the other things, set standards and provides guidance aimed at preventing the spread of the COVID-19 between shipboard and shore-based personnel. If an infected port fails to adhere to the IMO guidelines and standards, there will be ground of unsafe port. In the present case, owners have reasonable reasons to suspect that whether the pilot and the port have adhered to the requirements of the IMO, as I said previously, no crew on board was found to be test positive for the COVID-19 until and after the vessels reached Kalimantan, and the chief officers were likely to infect and contracted COVID-19 from the pilots. So therefore, owners argue that prima facie has a claim that the loading port was being unsafe. And in any event, owners submit that by accepting an order to proceed to unsafe ports, the owner do not waive the right to seek damage from the travellers for the breach of the absolute safe port warranty. The second ground that owner will rely on is the BIMCO infectious or contagious disease clause for the Voyage Charter Parties 2015 to seek the recovery of the EC's compensations and medical expense that already paid to the second officer, and also as a ground to resist the charter's claim for the delay in delivery of cargo, which set out in its billings and submissions. The relevant clauses will be the subclauses F3, which provides that any additional cost, expense, or liabilities whatsoever arising out of the vessel visiting or having visited an affected area, including but not limited to screening, cleaning, fumigating, and quarantining the vessels and its crew, shall be for charterer's account, and at any time lost shall count as lay time or time on demurrage. The subclause F1 said that the owner shall notify charterers of the decisions, but the owner shall not be deemed to have waived any of the rights under the charter party. And the minimum affected areas defined under the relevant clause would mean any port or place where there is a risk of exposure to the vessel, crew, or other persons on board to the disease, and or to the risk of quarantine or other restrictions being imposed in connection with the disease. And disease remains a highly infectious or contagious disease that is seriously harmful to humans. Note that the COVID-19 would fall within the definitions of disease, as it's highly infectious, contagious, and seriously harmful to humans. The COVID-19 can make people, especially older people, and those with pre-existing disease, could be very ill and can be fatal. And owner then submit that the loading ports also fall within the meaning of affected area as defined in the clause. And it was found chief officer test positive for the COVID-19 and the second officer was seriously ill. Considering the strict restrictions at all Chinese ports and the current status on board, the vessel will also face a risk of quarantine at the discharging spot in China. And therefore owners submit that it's fully entitled to rely on the income disease cause to seek damage against the charterer. That turns to the seeking indemnity from charterer for the compensations and medical expense paid to the second officer. So, subject to the diagnosis of second officer, if it's turned out to be positive to COVID-19, so as per the disease clause, that any causes, expense, or liability whatsoever arising out of the vessel visiting the affected area, that will be on charterer's account. So, as a matter of standard practice, the seafarer employed by Hong Kong flag vessels are subject to Seafarer Employment Agreement and the CBA Agreement. These agreements expressly incorporate the applications of Hong Kong Employees Compensation Ordinance and the International Maritime Labour Convention 2006. So under the ECL, the relevant case law in Hong Kong, so regardless of the nationalities of the seafarer and any arbitration clause in the individual's employment contract, the particular seafarer might have signed, the Hong Kong court will have jurisdiction to hear the matter and the compensatory regime under the ECL will be applied. Apart from the protections under the ECL, the crew are also entitled to receive benefits pursuant to the relevant applicable articles under the MLC. So, and an employee who infected with disease at work, which are not listed occupational disease, can also rely on Section 36 of the ECL to seek compensation from the employer. So far, he can prove that it is an injury or death or accident arising out of and in the course of the employment. So others submit that the accidents defined ECL also cover disease infected, which we like including internal accidents such as psychological change and change invisible from the outside body. And based on the facts of these cases, the second officer was infected during the course of the employment where he was working and then carry out the loading operations at the loading spots. And then therefore the owners submit that it is an injury arising out of and in the course of the employment. And by virtue of the CBA agreement, the owners are obliged to pay the EC and medical expense to the second officer. And but for compliance with the charter's order to the loading port, the second officer would not be infected with COVID-19. And therefore, owners submit that relying on the income disease clause, owner is entitled to seek recovery of any payments paid to the second officers in relation to the injury sustained, and this is reasonable and not too remote and should be recoverable. And in response to charter's claim for the delay in delivery of cargo, owners submit that the deviations to send the second officer to the nearest port is a justifiable deviations. This charter parties has incorporated the Hitsby rule, and by the Article 4 deviation in saving life is justifiable and will not be deemed as an infringement or breach of the rules or the contract of the carriage, and the carrier will not be liable for loss and damage resulting therefrom. And the criteria for the justifications of deviation is about reasonableness. As I said, the deviation is for saving the life of the second officer, and the fact shows that the second officer was seriously ill and he was unable to breathe. And notwithstanding that he's still receiving treatment, the symptoms showing that he's quite likely to be infected with COVID-19, and any reasonable master and competent master, for the sake of the health of the crew, it is reasonable for the master to decide to deviate to the nearest port so that to allow the second officer to receive the medical treatment. And on top, and as I said, without being clauses and charter, they had the delay on their own cost for instructing the vessels to the loading port. Regarding charter's counter claims set out in the pleadings for that the vessel was unseaworthy, it is charter's case that the vessel was delivered unseaworthy and all the owners has failed to keep this vessel unseaworthy. So the basis of the charter allegation here would be that the loading port was a safe port, and the infections of the chief officer was irrelevant to visiting the loading port and not relevant to contacting with the pilot at the loading port. And the classic definition of seaworthiness under the English law is that the ship must have the degree of fitness which an ordinary cargo owner would require his vessel have at the commencement of the voyage, having regard to all of the probable circumstances of it. As the Hitsby rule applies in this charter party. So under Article 3, owner's duty is just to exercise due diligence to ensure the vessel is seaworthy. In other words, to exercise reasonable care and skill. Owners submit that they have adopt safety measures to ensure that the crew are reasonably healthy and that will be not affected by COVID-19, for example, giving PPE and gloves and hand sanitizers, the guidelines that crew must keep social distancing, and as its owners submitted case that loading port was being safe, so it would be irrelevant to whether the seaworthiness of the vessels prior to visiting the loading port. And unless I could assist the tribunal further, that will be the end of my submissions.
Thank you, Counsel. I have a question. And that is, more a suggestion. Could you just take 2 or 3 minutes to walk us through the chronology of the possible source of the infection? And this is, I think council on the other side should also take note of this and perhaps address it when it's your turn. But I think it would be helpful for the tribunal if you could just, in point form, just take 1 or 2 minutes to walk us through the chronology of how the infection arose, or appears to have arisen, if it's unclear. That'd be very helpful.
Yes, and I suppose on that it would be when do owners say the infection occurred, when the infection was brought on?
So the chief officers was found to test positive on okay, let's reiterate that. So the first vessels tendered at NOR on the 26th of July, and then it proceeded to berth at the loading port. And then there was a schedule change of the chief officer, and was found that he was tested positive for the COVID-19. And then he was sent to the local quarantine center. And then on the 2nd of August 2016, loading was completed. And then at the same time, owners has arranged the crew to test for COVID-19. And the preliminary results show that there's no other positive cases. And then on the 5th of August, the vessel was en route to China. And then the second officer was reported he was sick. And then the master checked and concluded that he had COVID-19 symptoms and was actively monitoring his health. And then the pilots at the loading port was found test positive COVID-19 after the vessel sailed from the Kalimantan. So that was the chronology of the event. So first, the chief officers was found test positive upon the schedule change, and then the vessels would complete loading on the 2nd of August, and then after the vessels depart from the loading port, the pilot was found to be test positive, and then when the vessel was en route to China on 5th of August, the second officer was reported he was sick, and the master found that he has symptoms of the COVID-19.
Yes, thank you. Councillor, for the response.
Thank you. Good afternoon, members of the tribunal, and thank you for submissions of my Mr. Liu and Ms. Lee. We're here on behalf of the respondents, from the charters in this matter on the vessel, the third wave. So again, we also like to express our appreciation for the tribunal agreeing to have a hearing conducted by way of Zoom, and we also hope that everybody can hear us clearly. The respondent, basically will show that there was no breach of this absolute safe port warranty because Kalimantan was a safe port at the time, and because of that, the charters are not liable for the claims that have been brought by the owners, and rather will maintain a counterclaim for the delay losses which the cargo interests have brought, so we're seeking an indemnity. Turning firstly to the unsafe port point, so it's not disputed that the charter party contains an absolute safe port warranty. What this means is that the charters have to nominate, at the time of nomination, a safe port. But perhaps I'll walk through the charters version of the events and where charters think that transmission occurred. Crucially, owners have to demonstrate that in order for Kalimantan to be an unsafe port, that there was COVID-19 transmission there at Kalimantan. And it wasn't the case that the owners had basically delivered a vessel which already had certain members of the crew who were infected with COVID-19. We know, based on the facts, that the vessel had previously called Bangladesh and Singapore, but these are both places, it's across the whole world, these are both places where there have been recorded cases of COVID-19. So it wouldn't be out of the question that the chief officer who did test positive for COVID-19 actually contracted it at a different port prior. So what we see is that the vessel actually tenders an OR on the 26th of July, and during the crew change, after the test, which is shortly thereafter, and in any event, this is before the 2nd of August, the chief officer is found with a positive result of a COVID-19 test. This means that it's very unlikely that the chief officer could, in fact, have contracted COVID-19 at the loading port of Kalimantan, because there simply wasn't enough time. There's an incubation period for COVID-19. This is up to 14 days, and on average it would take about 5.7 days for symptoms to appear. So if the chief officer had, in fact, contracted COVID-19 at the loading port, which is alleged by the owners, and if it is the case that this was from the pilot, who also later tested positive, there wouldn't be a sufficient viral load for the chief officer to test positive within that short period of time. It must be the case that the chief officer had contracted COVID-19 previously, and then after disembarking the vessel at Kalimantan, having the test, that was when he was found to have COVID-19. And that would show that Kalimantan is not an unsafe port, but rather it's a port where the chief officer could actually disembark and seek treatment. So it's quite to the contrary, because Kalimantan was a safe port and had systems in place to deal with the COVID-19 global pandemic. So factually, the position of Chartres is that COVID-19 was not contracted at Kalimantan, even if it was found ultimately with the pilots. Turning to the legal issues, and this is without prejudice to the primary position of Chartres that, as a matter of fact, COVID-19 was not contracted at Kalimantan. Chartres submit that even if it was the case that COVID-19 was contracted at the loading port, the port was not an unsafe port. The classic definition of a safe port is well established and found in the case of the Eastern City, where Lord Justice Sellers said, in the relevant period of time, the particular ship can reach it, use it, and return from it without, in the absence of some abnormal occurrence, being exposed to danger which cannot be avoided by good navigation and seamanship. This is the classic position and has been affirmed in recent Supreme Court cases such as the Ocean Victory. And the issue of safe ports is typically applied to the physical characteristics of the port. So we see a lot of safe port warranty cases. This warranty is invoked in cases where there are grounding or casualty, such as in the Ocean Victory, it was a casualty. The focus of the definition is on the risk of damage to the ship and whether that damage could be avoided by good navigation and seamanship. This is a multifactorial analysis. And the threshold to finding that a port is unsafe is actually quite high. In fact, because COVID-19 is such a recent global pandemic, that we are not aware that there are any cases where any port has been characterized as an unsafe port due to COVID-19 or indeed any other epidemic. So at the time when the port was nominated by charters, Kalimantan was no different to any other port worldwide in light of the global pandemic. So Kalimantan did not present a particular risk of damage to the vessel, and it is hard to see how it should be treated as an unsafe port. Rather, the Kalimantan had systems in place in light of COVID-19. And the cases which have been cited, such as the Eastern City and the Polar Glory, aren't instructive because those again relate to physical danger to the vessel. And in this case, there was no physical danger in Kalimantan, and there are indeed no cases where a port has been held to be unsafe due to a global pandemic. In fact, Kalimantan has its own systems in place.
So, Council, do you accept that in principle or in theory, a disease or pandemic could give rise to finding of unsafe port?
In theory, yes, if it causes, I mean, we're talking hypotheticals where perhaps half the crew are incapacitated due to some epidemic on shore which has been brought on board. In theory, there could be a finding, I suppose.
Fine, thank you.
So charters are only liable for also damage which is caused by a breach in nominating an unsafe port, where in this case there has been no unsafety of the port, but perhaps rather due to the negligence of the owners or the master, the owners, servants, or the agents in failing to keep a vessel seaworthy or failing to have the appropriate system in place, there has been infection found on board. Turning to the BIMCO infectious or contagious diseases clause for voyage charter parties, which is being relied upon by owners, charters can accept that COVID-19 would fall under the definition of disease. However, Kalimantan does not fall under the definition of an affected area under this particular clause. The definition of an affected area is any port or place where there is a risk of exposure to the vessel, crew, or other persons on board to the disease, and or to a risk of quarantine or other restrictions being imposed in connection with disease. The BIMCO has provided some guidance on how this clause may apply in light of COVID-19, and it is a high hurdle, and owners need to show that the specific port could have served as a real risk of infection to the crew. The intention of this BIMCO diseases clause it was drafted during the Ebola epidemic in Africa, and it has very limited application unless the port really does not have any measures in place to control for the risk of infection. Again, unfortunately, given these novel circumstances, there are no legal authorities on the application of this clause. In fact, back in March, BIMCO was not aware, and I think still aren't aware of any crew members who are infected as a direct consequence of a ship calling a port, because ships are natural vessels which crews can be quarantined on. And it hasn't been shown that there's a risk of infection from pilots, inspectors, surveyors, or other similar persons going on board. Risk of infection can be managed and mitigated through proper procedures. So it would be very difficult for us to classify Kalimantan as an affected area in this case. And I think owners have also submitted that because the vessels are calling Chinese ports, and this would trigger possible quarantine in China because China has very strict controls in vessels calling a port in terms of COVID-19. That this clause would be triggered. That this interpretation would be quite absurd because in all circumstances, any vessels calling a port in China, this would trigger this disease clause, where if the whole world is an affected area, then basically no part of the world is an affected area, so long as they have appropriate systems in place. I'll let Mr. Lam continue with further submissions. Thank you.
Yes, so thank you, my colleague, Mr. Hoi, for giving the first part of the submissions. So I'm going to talk about the charter submission in response to the owner's claim for indemnity for compensation and medical expenses paid to the second officer, and then we will put forward our charter's claim for the delay in delivery of the cargo. And finally, given that this case mainly concerns the factual dispute at the Kalamanda port, so we would like to take this chance to invite our joint expert, Mr. Macau, to give out his expert evidence in the latest stage of this hearing. Basically, we can see that the owner's indemnity claim for the medical
Sorry, so can I ask you to slow down your submissions a bit?
Okay, sure. Yeah, thank you. We can first see that owner's indemnity claim for the compensation and medical expenses paid to the second officer is basically based on the vehicle disease clause. And they're trying to say that if this clause is operated in our case, then the owners will be entitled to an indemnity claim. But we as the charters is maintain that the owners are responsible for the compensation and medical expenses paid to the second officer. While it's clear that the second officer was hospitalized for 1 month and suffered from reduced lung function, but on the facts, it is unclear if the reduced lung function was entirely caused by, or if at all, by the COVID-19. So we urge that maybe some medical evidence has to be adduced in order to support the assertion. And while COVID-19 is a possible cause of the second officer's reduced lung function, this is not conclusive. And in the Employees' Compensation Ordinance, the Schedule 2 provides an exhaustive list of the occupational diseases. And although the owner submit that the COVID-19 could be classified as one of the occupational diseases, so as of now, there has been no change in law on this point. So in any event, currently COVID-19 is not on the list of the occupational diseases. And put it differently, that means under the ECO, the owners could not have asserted that this because the COVID-19 is an occupational disease, and therefore they have made an early settlement with the second officer to pay the compensation and the medical expenses. In other words, they have to resort to the long cause, that is to show that the injuries arose out of and in the course of the employment of the second officer. And we therefore submit that the charters are not liable for the indemnity. And in relation to the personal injury by the accident grant under Section 5 of the ECO, it is also submitted that the owners are not obliged to provide compensation to the second officer. This is because in order to prove a claim under Section 5 of the ECO, it requires personal injury by accident. And in a Hong Kong case, that is the Sidway versus Burton Industrial Limited. The Hong Kong Final Appeal has made clear that the expression injury by accident encompasses both cause and effect. And that means the accident must be distinct from the injury, with the accident being at least a contribution cause and injury being the effect. So the owners, they have to prove both the accident and the injury. Without a known cause, the injury could hardly be said to be by accident, and it is therefore submitted that the owners fail to show that the second officer's reduced lung function is caused by a known cause, for example, to be supported by medical evidence. And in this case, we submit that the owners should not have settled with the second officer at an early stage for a compensation under the ECO. Simply because it is our primary position that the vehicle disease clause cannot be relied on, as submitted by my colleague Mr. Hoy previously, and therefore, if owners they have a duty to mitigate in any event, and therefore they should not have pay such sum of the compensation and the medical expenses to the second officer. And we are going through the charter's claim for the delay in delivery of the cargo. So the charterers submit that the owners are responsible for delay in delivery of cargo, and therefore the charterers should be awarded damages. So we maintain that the law implies a duty in the owners of a vessel, whether a general ship or hire for the special purpose of voyage, to proceed without unnecessary deviation in the usual and customary course. And this is supported by an old case of Davis and Correct. So charterers might accept that a deviation for the purpose of saving life is justifiable, so long if it does not exceed what is reasonable for the purpose of achieving a justifiable object. And the devious course which is followed must be a reasonable and prudent one. However, we submit that to focus solely on the deviation itself is the point. And instead, the tribunal should be reminded of the events leading to the deviation. And it has always been the charterer's primary submission that the vessel was delivered unseaworthy by the owners. Or in the alternative, that means the owners failed to keep the vessel seaworthy. And under a voyage charter, owners are using the vessel to trade for his own account. Therefore, the owners decide and control how they will exploit the earning capacity of the vessel, and what trades they will compete in, and what cargoes they will carry. Therefore, it's always the owners to bear the full commercial risk and also expense and enjoy the full benefit of the earnings of the vessel from the voyages. And more importantly, the owners have to bear the expense of maintaining the ship and also the crew. This is well established in the House of Lords case, the Whistler International Limited. And the present charter party incorporates Article 3.1 of the Hague Rules, and which obliges the owners of the vessel to make the ship seaworthy. And we submit that owners have failed to do so. We will remind the tribunal that owners' obligation under Article 3.1 is not subject to any exceptions in Article 4 of the Hague Rules, and therefore charterers claim against owners for all losses and damages suffered as a result of owners' breach of the unseaworthiness. Firstly, we submit that this is a factually sensitive case. It is entirely unclear what systems and measures have been in place on the vessel prior to the vessel tendering NOR and Kalimantan port to ensure that crew health and better transmission of COVID-19 will be prevented. And if we may avail this chance to draw the tribunal's attention to paragraphs 5 and 6 of the agreed facts. So as we can see that, so it's likely on the agreed facts that is in the about the sequence of the contraction of the COVID-19 is the chief officer who was tested positive in the first case, and after the vessel sailed from Kalimantan port, then the pilot was tested positive for COVID-19. So we would like to we would like to draw the tribunal's attention to two very crucial facts of this case. That is first, which was the real cause of the contraction of COVID-19 by the chief officer. If the sequence is that first is the chief officer who contracted the COVID-19, and then it was a pilot who was tested positive, then could it be the case that it's the chief officer who had those symptoms even before the vessel arrived at the Kalimantan port? So if that's the case, this is clearly the owner's responsibility to maintain the seaworthiness of the vessel. And of course, the second important factual point is whether the owners or the master had taken reasonable steps, whether there were some safety protocols or measures in place about testing the COVID-19. So as we can see, the timing for the contraction of the COVID-19 by the chief officer was likely on around 26th July. That is around that is after the vessel NOR. But then the first test to all crews on board the vessel, and it's just a preliminary test, was carried out on 2nd of August 2012. So charterers would submit that there had been some delay in the preliminary test of the crews by the master on alternatively the vessels. And that's why we were
Sorry, Mr. Lang, if I can interrupt. So, just so that we can understand your case, are you saying that you think the chief officer had COVID before the vessel arrived at Kalimantan? Is that charterer's position?
Yes, this is our position.
And then I'm wondering, if that's the case, the chief officer had COVID before the arrival at Kalimantan, so there's COVID on board the vessel before Kalimantan, but then all the crew on the 2nd of August test negative. How would the charterers explain that?
Thank you for your question, Mr. Chairman. So we submit that even maybe there is one crew who's tested positive for the COVID-19, that doesn't mean that all other crews, they may have the chance to contract the COVID-19 as well. And it's because on the given facts, it's very clear that about the sequence of the positive case of COVID-19, that is first the chief officer who had been tested positive, and it's afterwards that is the pilot being tested positive. So we submit that it's the owner's burden to prove that the cause of the contraction of COVID-19 of the chief officer was caused by events at the Kalimantan port, which can only support the case.
And the burden is on owners because of a duty to exercise due diligence to make the vessel seaworthy, or another reason?
Yes, correct.
Okay,
Yeah.
thank you.
So about the second point, this is about the delay in testing of the vessel. If we could cite the facts again, that is on the 26th July 2012, there was a scheduled change of the chief officer, and the outgoing chief officer was then tested positive for COVID-19. So we submit that the owners should have carried out the test earlier. And on this point, we would like to invite a very experienced journalist, that is Mr. McCarr, to opine on what measures that should have been taken by the owners to ensure the seaworthiness of the vessel. And we may have the permission of the tribunal, and we will invite Mr. McCarr to challenge the
Yes, thank you, Councillor. Mr. McCarr, could you please come forward? Thank you. Could you state your name and position and tell us why you're here?
Good afternoon, members of the tribunal and the consuls. My name is Jagmeet Makkar, and I have been jointly appointed as the expert witness to come and give answers to the questions that you may have.
Very good, thank you. Now, Mr. McCarr is a joint expert, so he's been appointed to give evidence mutually by both parties. I think we can probably dispense with any oath or formalities of that nature. And Council will have some questions for you.
Yes, so thank you, Mr. McCarr, for giving your evidence in this hearing. So may you first ask Mr. McCarr, so what is your background or credentials?
By way of my background, I'm a marine engineer by education. I have sailed out at sea for 11 years till chief engineer, then I came ashore. And thereafter I was doing new building, ship management, moved on to chartering, sale and purchase. Have been in shipping for almost 39 years.
Yeah, thank you, Mr. McCarr. We have one question. That is, what measures can be taken by owners of vessels to ensure crew health in light of the COVID pandemic, which has lasted for almost a year?
Council owners of the vessel can implement a number of things. The most important one is the management system, which may include repeated screening, training, response systems, crew changing in a proper accordance with the systems, suitable prevention, control measures, as well as personal protection of the crew members that they can put in place. Owners can also implement the emergency response system should positive cases found, and also they can put in place suitable reporting system of such cases. Now, some of these key measures, they include, but they are not limited to, personal hygiene, awareness about self-protection, use of protective equipment, isolation, communication with the patients, and most important is dealing with their mental health problems.
Thank you, Mr. Kat, for answering. One more important question is that, in your opinion, so far, do all ports have measures in place to prevent the transmission of COVID-19? In our case, Kalimantan port there's no lockdown in Kalimantan port, but do you know if there's any other measures also in Kalimantan port to prevent transmission of COVID-19?
Council, since we are talking about the interaction between port and the ship, so please allow me to focus on the safe shipboard interface between the ship and shore-based personnel. Yes, I would say that all ports, albeit to varying degrees, have measures and procedures in place to prevent the transmission of COVID-19. They have been put in place as IMO, there is a circular called 4204, and especially the addendum 16, which is dated 6th of May 2020, which specifically deals with the interface between shipboard personnel and the port. So that is there, and also the port itself, the national administration, the local authorities, professional organizations, and the employment companies, they are making sure that as I said, albeit to different degrees, to make sure the ports are following the systems. And you asked about Kalimantan port. Kalimantan is actually a big island. It has got 5 different areas with many ports. So what I would say that yes, measures are in place at ports in the region from Tarakan to Tagonio, Anchorage, and both east and west side. In addition to the IMO circulars, the Indonesian Directorate General of Sea Transportation, DGST, at the Ministry of Transportation, they have issued several circulars aimed at preventing COVID-19. I would like to especially mention the letter number 11, which is quite relevant here. So it is in place, it is being done.
Yes, thank you, Mr. Khan. So we have 2 more questions for you. So the next question is, what measures can be taken by owners to prevent the transmission of COVID-19 once the vessel is at port and in berth?
Well, the key measures, they include the ship-shore personnel exchange effectively, which can be achieved by establishing temporary epidemic control measures on the ship, minimizing the ship and shore personnel exchanges, and not allowing visits and family reunions on board. What is important is that boarding of the outsiders should be strictly limited within a specified perimeter. A tally room or a reception, normally it is made where it is fully manned, and outsiders, including it could be agents, tallyman, suppliers, etc., they are not allowed to enter the living spaces, the accommodation, including pilot and other people. If they have to come, they are taken from outside onto the bridge, given proper equipment, right? They go inside maintaining the distance. When they come out, all those equipment is taken off from them, sanitized and destroyed, and they go back with the new equipment. So all these measures can be taken by the owners to prevent.
Thank you, Mr. Makar. So the last and the most important question is that, so on the facts, he said that the the chief officer was first tested positive. So in your expert view, what measures should owners take once it is confirmed that a crew member has been tested positive for COVID-19? And do you think owners had taken reasonable steps? This is especially in light of a slightly delayed in the testing of the crews after the positive case confirmed with the chief officer. Thank you.
Yeah, in this case, when the crew member or the chief officer tested positive, that was at the time of signing off. It was not a routine test. He was signing off, so before he could send back home, the local policies required him to be tested, and he tested positive. So when situation like this occurs, of course, all the crew members, the company policies as they decide, they make sure they don't come in contact with the person. A lot of isolation is maintained. And the disembarkation is done by the shore medical people. So that is something very important. And once that is done, of course, in terms of quarantine, that is one step which is done. Second thing, it is not sometimes necessary to do the COVID testing of everybody else. But in this case, I have noticed that yes, has been tested by the company, by the owners. Yes, that is what I see it has been done.
Thank you, Mr. Maka. And we have no more questions to the journalist.
Mr. Maka,
Does, Councillor, I'm sorry, Mr. Joe, was that?
okay, Mr. Maka, I have a question for you. Could you let us know regarding the load port, do you find any measures in place for routine testing of the pilot?
From my experience, what I have seen, not only just this load port, generally pilots are not put through the routine testing for the COVID-19 test. The reason being could be, I don't know, I should be dwelling into reasons, but no, it is not done as a regular practice. Proper distancing, going to the wheelhouse from outside, wearing protective gear, I think that those are the precautions which are taken.
Okay. I have another question is that you sounded familiar with the international regulation standards. Is the port required to follow any local regulations on the IMO guidelines? Do you have a handbook?
International regulations, of course, which are there, which then the port states, flag states, they comply with. Also, there are local regulations, as I mentioned, the Indonesian Directorate of Sea Transport, DGST regulations, especially letter number 11, that is very relevant. So that is, generally they have to comply with that. Thank you.
Okay, thank you, Congressman.
Thank you. Mr. Yes, I wonder if we could, I have one question. Could we just focus in on the actual conduct on the bridge that the pilot has actually come on board? Could you actually tell us precisely what happens? You told us that there's distancing and cleaning, disinfecting of surfaces and equipment afterwards, but what would actually happen at the moment the pilot is required to take control of the vessel? Is the first officer on the bridge with him? Do they wear masks or ventilators? Or could you just drill down on that a little bit?
Sure. When the pilot comes on board, of course, we have to make sure he's wearing proper equipment and his temperature is checked. And he's taken to the wheelhouse from outside. He's not allowed to enter the accommodation space. So once he arrives on top, on the bridge wing, he is given the proper equipment. He wears that and he goes inside. So once he is inside, proper distance is maintained. After he has done what he is supposed to do, bring the ship in or take the ship out, then his equipment outside is changed, mask and everything, and he wears his own stuff and he goes out. And whatever he was wearing, then it is destroyed, properly disposed of. That is important. And the wheelhouse itself, after he has gone, is disinfected.
And then is he alone on the bridge at any time?
No, captain is with him on board, and the helmsman will be with him, who will take orders to steer the ship.
Counsel for the claimant have anything arising out of any of the questions?
We don't have any questions. Thank you.
Thank you. Does that conclude your submissions, or do you wish to follow up?
Yes, sir. Yes, Chairman, these are all our submissions. Thank you.
Thank you. Your reply and submissions?
No more submissions. Thank you.
You have no reply?
Sorry, just clarification.
Sure. So we'd like to respond to the question that, so owners are making its case that the fact, owner's case is that the powers impact the chief officer, so experts has been very helpful that saying how the sanitizations and how the power separating the room. But then owner would say that if it was the chief officer being found to have positive COVID-19 before visiting loading port, how could it be permitted to enter to the loading port? And how could it explain that why all the crew were not found test positive up to and until at least on the 2nd of August? So owner would still argue that probably at the time when the pilots on board, possibly there may be like touching on the rail or surface that could be leading to the spread of the COVID-19. Of course, it's subject to how the tribunals assess the experts' evidence. And owner will maintain that it's at least based on the Binco causes, it still is affected area and there's a disease existed, and therefore owners receive travelers claim for the delay, and owners maintain deviations is justified, at least for the safety of the vessel and the crew. Yes, this is the end.
Thank you. Fellow arbitrators, do you have any questions? No? Mr. Joe, do you have any further questions?
Can I have one more question for the claimant? Can you justify there is an urgency to make the decision of compensating the crew members so quickly to make the decision reasonable? Can you elaborate a little bit more on this?
You mean for why that times deviate to send? Well,
in such hasty way, because apparently I'm not familiar with Hong Kong law and the local employment ordinance. So would you please elaborate a little bit more? If you wouldn't do that, what's the liabilities with the owner would face with?
In terms of the, well, please correct me if I'm wrong, that you're about the compensations to the second officer, because in Hong Kong that the issue is a non-fault basis. So you do not really have to prove that whether there is any wrong on the part of the employer or employee. But the test is that if he sustains injury, which this case will say that disease, an internal change of the body could be classified as accidents. Of course, the charge will disagree on this point. And if he has sustained in the course of the work, then strictly the owners must pay the employees' compensations to the crew. And this is also contractually required, because in the CBA would say that the assessment, the formula of calculating compensation would be in accordance with the ECO. But under the contract, the owner has to pay the medical expenses to the crew. And therefore, this makes it's justifiable and reasonable. And in fact, if the case be dragging for longer, the injured person may bring cases against the owner, and there will be unnecessary costs being incurred. So, from the owner's point of view, it's reasonable and sensible, and in fact, it's contractually obligated to pay the medical fee and expenses to the second officer. So, I hope this can address your questions.
Okay, thank you, Council.
Well, thank you, Council. I think that brings the submission and evidence stage to an end. Now, as with the previous phase of the mock arbitration, in reality, a case like this, the tribunal would probably reserve judgment and hand down a written award later. Or alternatively, the parties could come back for a further sitting day for some closing submissions, and it would still be rare to announce a decision on such a day, but it's possible. On this occasion, the tribunal are going to proceed on the basis that we have conferred, and we're going to give some, announce our decision and give some very brief reasons for that now. This case arises out of a call of the vessel Third Wave to Kalimantan, a port in Indonesia. Now, jumping ahead slightly, the immediate cause of the claims is that the second officer was found to be ill and showing symptoms of a respiratory condition sometime after the call at Kalimantan, when the vessel was en route to China. The master monitored the situation, but the second officer became seriously ill, and the master made a decision to deviate from the intended route and seek medical assistance at an intervening port. The second officer was hospitalized for a month and incurred some expenses. And the owners settled the claim of the second officer, including compensation due under Hong Kong law, a medical allowance and some expenses. And it's that that gives rise to the claim. The owners claim that the charterers nominated an unsafe port, alleging that Kalimantan had a COVID-19 risk, and that deviation was justified. So the owners seek an indemnity from the charterers for the compensation paid and the medical expenses paid to the second officer. The charterers, on the other hand, claim that Kalimantan was a safe port, or owners have not established otherwise, because there was no lockdown. And they claim for delay in the delivery of the cargo arising out of the deviation. Now, going back to the facts, there's a very short chronology that leads up to the call at Kalimantan. The vessel went to Bangladesh, and then via Singapore, where it picked up bunkers, and then continued to Kalimantan. The charter was on the 21st of July. Just 5 days later, the vessel tendered NOR at the load port. The chief officer tested positive after a scheduled crew change. There was then a contract tracing exercise that found out that the outgoing chief officer had only interacted with the pilot. On the 2nd of August, so that's just 7 days later, the vessel completed loading and proceeded from the load port. And then on the 5th of August, the incident with the second officer arose. So there's a very tight timetable there, and all roughly within the sort of ambit of 14 days, which is the incubation period for COVID. So turning to the claims, the tribunal finds that the owners have failed to establish that Kalimantan was not a safe port. We concluded it is possible in law for disease to make a port unsafe, and I think that was accepted on both sides, but it's very unlikely. COVID presents a worldwide risk. Excuse me. Of course, there's nothing unique to Kalimantan. For such a situation, the tribunal would have expected to see evidence of some sort of systematic failure at Kalimantan that really heightened the risk of COVID infection way above the ordinary risk of catching COVID anywhere else. So we find that the safe port claim fails. Owner's second claim was under the BIMCO clause. Now, under the clause, they can claim additional any costs, but those costs must arise out of the visit, and so and they must arise out of the disease itself. this then requires proof of how the infection actually got on board and who had the infection first, the pilot or the first officer, and how the second officer became infected. As I've said, there was a very tight timetable. For each claim, the claimant bears the onus of proof. So here, the owners would have to establish how the COVID infection came on board. The tribunal was unable to conclude that the pilot brought the infection on board. It is possible that the first officer contracted COVID at Singapore or at the port in Bangladesh. And so we also find that the BIM clause, disease cause claim fails. Dealing with the third aspect of owner's claim, the tribunal finds that the owners voluntarily settled with the second officer for their own commercial reasons. We make no criticism of that, but we were persuaded by the charter's submissions that there probably was no liability under the employees' compensation ordinance. So the owners have failed to make out causation between their decision to settle the compensation and the suggestion that the pilot brought the infection on board. So in conclusion, we find that owner's claim fails at each of the three stages. And that leaves the charterer's claim for deviation. And again, the tribunal found that causation was not made out because as the claimant on the counterclaim, equally the charterer has to show where the infection came from. It's not entirely clear that the second officer contracted COVID. It does appear to have been a respiratory condition of some sort, but there doesn't seem to have been any conclusive proof before us that it was, in fact, COVID. No tribunal would lightly interfere with a decision, retrospectively interfere with a decision of a master based on safety. And we cannot find that the master's decision to deviate for life-saving purposes was unreasonable. And so we find that charterer's claim fails as well. So in conclusion, both claim and counterclaim fail, and that's something that frequently happens. So it's an honourable draw, and in the circumstances, I think we would hold that each party should bear its own costs of the proceedings. Is else, do you have anything to add to that?
I agree.
Yeah, thank you. Mr. Joe, did you have anything to add?
I concur. No.
Yes. Thank you very much. Thank you. And that brings the proceedings to an end. Thank you.
Hello? Hello? Yeah, we have a unanimous tribunal, and we've got thousands of questions popping up on the screen. There we go. Any questions in the room about this? Yeah, we have one. Can you see the question? What is the tribunal's view on the second issue that security should not be ordered because the counterclaim is merely a repetition? Oh no, that's previous.
That's first phase.
That was the previous. Right. Thank you.
I'm happy to answer it though.
No, too late. Yes.
Hello, Mr. President, Your Excellencies and Councillors. Shall we further our topic under these situations? Suppose order the unsafe port, and there has so many arguments in these days of maybe like the force majeure, the principle of fundamental change of circumstances, and maybe the frustration of contract. May this is argument to assist the charter to exempting from the compensation. Does that make sense?
Do you understand the question?
Yeah, force majeure, I know that force majeures come up a lot in connection with COVID, and there's a lot of legal articles lying around dealing with that topic. It doesn't seem to have come up here because neither side has claimed that it was unable to perform any of its obligations under the Charter Party. And that's the sort of inquiry you would need to get onto force majeure. So it doesn't seem to have arisen here, although it's certainly a hot topic in terms of COVID. Bill, did you have anything?
Well, I think in a way, probably what your question is going to is you're saying that COVID is a pandemic. It affects the whole world. So are we going to find that every port is unsafe? Or are we dealing with force majeure? So.
And I was wondering, because there's no, from my perspective, there's no authorities to maybe to test whether it's truly unsafe. Because from the defendant, I didn't catch up with defendant how what's the test of to improve or to prove that it's a safe port. Sorry, you didn't get more point.
Yeah, I think the situation was that it would be for the owners would bear the onus of proof on unsafe port, having made the allegation. As counsel for the charterers said in their submissions, it's unsafe port is normally concerned with navigation type issues and weather and tidal issues and groundings and collisions and visibility and things like that. And question in that regard, question of the time conditions at different times of year arise and that sort of thing. With COVID, it's a pandemic that's all over the world, and there don't seem to have been any cases yet. But if there was a case, it would be very specific to the facts in question. It would be necessary to prove that there was something special about that port and conditions at that port or procedures at that port that made it unsafe. So it's difficult to generalize simply from the fact that COVID is a worldwide pandemic. It's difficult to make any general assertions about safe ports. It would depend very much on the particular case.
I think the question probably at the very beginning is that if your presumption is that if the port is an unsafe port, and then whether charters can rely on, for example, change of circumstances, force majeure, or frustration of the counterparty as defense to against the owner's claim for the unsafe port. Our case scenario is that the applicable law is Hong Kong law, the English law. So under common law, I believe you also understand that there's no concept of force majeure. And unless the parties in the charter party make it clearly. And secondly, for the change of circumstances, the hurdle of proving it is very difficult, very high. Okay. And thirdly, for the frustration as well, it is very difficult for the charters to prove. And in any event, your presumption is already very unfavorable to charters that the port is unsafe, and then in that circumstances, the charters will not be able to rely on any unless the defense available under the law or the charter party. Otherwise, they will not be able to rely on whatever, even the frustration of the charter party to resist the claim. I think that is the answer of your question.
Yes, I think Mr. Liu have has raised very interesting points in this regard. Like the pandemic is sort of overwhelming everywhere. And the force majeure or the contract frustration is sort of a very hot topic pursued in any corner. As a civil law practitioner, I think for us to understand that force majeure is very self-evident. It's on our contract law or every civil law jurisdiction, but in the common law system, the very comparative concept of that is contract frustration. The threshold is really high, but I also detected some consolidation of the two ideas in some sense. Maybe last year the civil appeal of the English court has handed down a very similar new precedent. But the binding effect is still to be observed, apparently. So maybe there's someday there's I don't know, maybe an emergency of the two ideas in the future. But normally, or in practice, we will advise our client to provide or incorporate as many as possible any accidents or any unexpected circumstances to happen in their executing the child party. So I think that's the answer you're looking for.
Yeah, we have a question, maybe. Just looking at the procedural aspect of arbitration itself, normally, how often would the expert witness take up the role of an investigative person and not just draw upon his experience? Excellent question.
Well, I think one of the interesting things about this mock arbitration was the expert witness in this case, as I understand it, was appointed by both parties. So we're already doing quite well because by agreement, everyone has agreed on a single expert, which is fairly rare. And so in our case, the expert is in no sense impartial. And I think we saw there that where you had this jointly appointed expert, they were able to provide a lot of assistance to the tribunal, and the tribunal could have a lot of confidence in the answers which the expert witness gave. And so there could be an element of an investigative role at a fairly low level.
Yeah, it tends to be a bit of both with experts. So experts are selected for their expertise in a particular field and often can answer questions put to them purely from their experience and memory. But on the other hand, experts do sometimes do investigative work and arrive at conclusions that they didn't know before the case began. So, for example, sometimes some material has to be tested for strength or moisture or something like that. And of course, the expert doesn't know the answer in advance, so they would perform some test, and that test would be within their expertise. So, and they produce the answer for the parties or for the tribunal. So it can be a bit of both, a bit of purely from their background knowledge and from work done for the purposes of the case. But I've certainly seen experts' reports over the years where they confess, openly confess that to answer the question, they conducted some research in textbooks in the area and arrived at conclusions after having carried out some specific research. So unless it's sort of guesswork and they're straying outside their expertise, then you would say, well, you're no more qualified to look that up than anybody else is. But if it's well within their expertise, it's perfectly okay for an expert to say that this particular engagement caused them to carry out some specific research to arrive at their answers. A bit of both, yeah.
Yeah, I would like to add there. Microphone, please.
Sharad, there was a question whether the pilots go through the COVID testing, yeah? So when this thing came up, I think this came up sometime very early in the morning. So I made almost 6-7 calls to various agents in Indonesia, Malaysia, Singapore, checked with the guys here, India. I said, what are the SOPs? You know, do you find the testing of pilot in the standard operating procedures of the port as well as the ship? They said, no, we follow the standard system, and that's the keeping the distance, you know, taking the people up from outside, and also changing the protective equipment, and also disinfecting the wheelhouse. He said, that's all we do. The reason that was given, it was very interesting. They said, pilot might be going to 2 ships, 3 ships every day. And every day he is going to all these places. Now what happens? This is not something if today you get it tested, so it's a guarantee for the next 14 days. No, it could happen after 4 days, 5 days, as you rightly mentioned, it's 5.7 days is the average. So it makes it a bit difficult for that system to put in place.
Okay, we don't have any other questions on Zoom. Just to say that COVID-19 is a big issue in arbitrations at the moment. We see quite a few coming across the board with demurrage claims, detention claims, all kinds of other claims. So it's quite interesting. Yes, sorry. Yeah. That's what we've answered. Yeah.
No, there's a new question. The chat box.
All right, okay. Which kind of additional arguments or evidences would have turned the decision in favor of owners? Hypothetically.
Oh, 对对对，就是两个问题。
Well, I think, as I said in my reasons, we would have, in a proper safe port claim, we would have expected to see a much more thorough analysis of circumstances at the port, rather than simply saying, well, the vessel called at the port and some COVID was detected, and it's not even clear, it wasn't even proven that the COVID was actually contracted at the port. So we thought that fell well short of what would normally be necessary to make that a safe port claim. So some structural evidence about events, procedures, etc. At the port. And then ideally some more evidence on the actual fact about how the COVID got into the crew on this occasion. But as we sort of said in our reasons, this case is probably one where it was a genuine mystery, and neither side was able to show on the balance of probabilities where the COVID had been contracted. And each claimant bears the onus on their claim, so it's perfectly possible for claim and counterclaim to fail, and that happens in arbitrations all the time.
Okay, I think we've answered both of those.
There are two.
Answer the second one, but not the first one.
Not the first one, is it? We did. Okay, since a crew sickness which is not involving charterers directly, so if in this case the port was found unsafe, would this affect the tribunal's decision? The first one. From Captain, the both from Captain.
Well, I think in general terms, there is a risk of infection everywhere. Every port, there is even in this room, everyone in the audience is wearing a mask. I don't think you can see them online. So there's a risk of infection everywhere. But when it comes to looking for safety, you have to find something extra, something additional to that risk which we're all facing. So really, it boils down to, is there some kind of systemic failure at the port? It's not even, in my opinion, it's not even a one-off human error. For the port to be unsafe, you're looking for something systemic in that port.
Okay, I think I'll just look behind me again. Yes, we're done. And what I've got to do now is to thank everybody, but also hand over to Mary, who's online, I think, who's going to make the final comments. Can you hear me, Mary?
Yes, I can indeed.
Okay, it's over to you.
Can you hear? Okay. Well, this is the third mock arbitration that we've done. Well done. I'm sorry I'm not there in person. I hope that next year I'll be there in person. But look, we cannot seem to get away from COVID-19. Even when we were planning on doing this mock arbitration, we had to have a plan B in case we couldn't do it entirely face-to-face. So what we have today is a hybrid mock arbitration. Maritime Arbitration Week was cancelled, has been cancelled, but we thought this had to go on. And I'm so pleased that it has, because it's been done really well. Last year we had some audio problems, but this year it seems to have gone pretty good, I should say. So that's the first point I'd like to suggest. We saw in the procedural, a session on security for costs. I would like to suggest that one of the factors for the reason for why you don't see so many security for cost applications succeeding in arbitrations as opposed to courts is that with the courts you can actually rely on the fact that the plaintiff is out of the jurisdiction, whilst in an arbitration, and in a maritime international arbitration, that cannot be used as a factor. So that is one of the contributing factors as well to why there are not so many. Substantive session, as you can see, a very usual dispute, really dealing with deduction of hire. But here again, the factual matrix is something that we cannot, although we've not yet seen it filtering in large numbers in arbitrations yet, but I reckon, and we think that it's coming. So again, we cannot get away from COVID-19. The second point I'd like to suggest in my closing, since I'm also representing as a co-organizer from the Chartered Institute of Arbitrators East Asia branch, when we sent out the flyer about this mock arbitration, we received a complaint actually from a member who's also a former committee member, and that complaint was about the lack of diversity in our mock arbitration. I suppose, as someone pointed out in our committee, 4 out of 10 of those who are taking part in this mock itself are females, are women, which is in some sense not a bad proportion. But on the other hand, when you look at it, I think what the complaint was directed at was the fact that although there are counsels who are women, the tribunal are all males. And then I was a bit embarrassed by that because I'm also a co-organizer. But when I look around and I try to think of other women maritime arbitrators in Hong Kong like myself, I'm hard-pressed to find another. So it was quite difficult, but that does not mean that we cannot try to do better.
Mary, don't worry. COVID will soon thin us all out. It's a short-term problem.
So what don't you say? Yeah, but then I'd like to suggest that diversity is not just about gender diversity. It's about inclusiveness. It should also include that, especially in maritime arbitration, that we should be inclusive. That tribunals should also include non-lawyers. I think maritime arbitrations can benefit from the technical expertise of other professionals, apart from lawyers as well. That's usually reflected in LMA arbitrations, and it can be reflected in arbitrations in Hong Kong. Cultural diversity, that it, sorry to the two members of the tribunal, that there doesn't need to be this thing that is all pale, pale and stale. We can have cultural diversity, we can have, I'm very pleased to see that we have a tribunal member from, I believe he's in Beijing at the moment. We can have more homegrown arbitrators as well. So let's embrace diversity. It's certainly promoted by the Chartered Institute of Arbitrators. When I was chair, I set up the diversity subcommittee, and that has been continued by the current chair. And I know that our head office in London is very keen on supporting diversity as well. I don't have a lot of time, but I cannot finish off without thanking everyone for this mock arbitration. The organizers, especially, if I might just single out Brad as a driving force in putting this together again for the third time. And also it's very well supported by the Department of Justice. You are in that premises, that venue itself. The DOJ has always been supportive of maritime arbitration, and I can tell you, I've seen it firsthand, that is the case. It's also well supported by CMAC, HKMAG, HKMLA, HKIR, and CIR, East Asia Branch. Thank you to the role players, you did a marvelous job. Let's give a hand to all these role players. They had to take time out of their full-time work in the office to prepare for this. We also thank the MCs, the moderators, the tribunals. But not least of all, the audience that has participated by Zoom and in masks in person. Thank you all. This wouldn't have happened without you. And do continue to support maritime arbitrations, especially in Hong Kong. But also embrace the changing times, adapting to a much more IT environment, but also embracing diversity and inclusiveness. That's all I'd like to say. Thank you very much.
Yeah, I just echo the point on diversity. One important form of diversity is common law, civil law diversity, and that's increasingly important in arbitration. So it's great to have a civil lawyer on the panel this time.
Okay, so thank you, Mary, wherever you are.
Certainly.
Is this working? Hello? Hello? Yeah, it's working. Thank you, Mary, wherever you are. And thank you, everybody, online and in the I think we're done for the day, right on time. What? 4 minutes late.
Thank you all.
Okay, thank you. Thank you all very much.
停。稍等。
等一下。
Okay.